And believe me, what John says is right. Do not fall into the trap of believing the members of Parliament when they talk about their constitution, because they do not know what they're talking about. Ladies and gentlemen, John Bingley.
First of all, to point out that I am a layman, and on my way through doing all this stuff, I've just been studying the Constitution, the English Constitution. We have much written Constitution, as you're about to see. Really what I want to do is to empower people to understand that we do have written Constitution and roughly what it is. It's quite a bit of complex stuff here today. I hope I'll try and make it clear. You're not going to run away with it all, but if you get a good 10% of it and go away with that, you'll have got some really solid facts from which you can base your future judgments. So the first thing is that how many times have we been told that we have no written constitution? That's something that if you ever made any inquiries about constitution, that's the thing we're always told. But we do have a constitution that has evolved and been written over many centuries, and all those who hold any office are contracted to obey it by their oaths of office, and of course by the rules of the law. So there is a question of oath of office and rule of law, and this is of course basically an honour system. So the question is, looking at it from a sort of engineering point of view, from a mechanical point of view, has Parliament been accorded absolute power? That's a question one would want to ask oneself. If there's no constitution, then presumably Parliament has no control over it, and it can do entirely as it wishes. If so, there can be no constitutional limitations to control it. Conversely, if there is constitutional limitation, it is plain that it ought to act as a firm limitation, and the citizens, of course, should be able to utilise that to keep the executive and the governing body in check. And of course that means there must be means of obtaining redress and remedy. And that, of course, is a vital point. And ultimately, as was Magna Carta, there's actually a right of resistance, so that if the Constitution is disobeyed, that ultimately, when all legal means have failed, then there is an entitlement to resist. Well, those who say there's no written constitution, here's a pretty good document, recognised the world over. This is the Magna Carta. There's 4 copies still in existence. 2 are held by the British Library just down the road from here, almost opposite, I think. And this one is Salisbury Cathedral's copy. And of course this was a document which King John was forced to sign at the time. It's been confirmed, I believe, some people say 32, some people say 35 times, but one way or another there have been disputes about points, important points within it throughout our history, and each time Magna Carta has prevailed. So it's a very important document. It's very fundamental. One of the most important reconfirmations of Magna Carta, for those of you who are not really familiar with history, in 1688 we had what is known as our Glorious Revolution. And there are 2 documents depicted here. The one nearest me is our Declaration of Rights from 1688, and that had a statutory form, the Bill of Rights, which is on the right-hand side there. Sorry, it's my right, your left. These are very important and very interesting documents. They exist, as you can see, they're current. That's my hand holding the Declaration of Rights on the left, and that's how I came to start this whole quest, really, was that I knew a little bit from my history at school that we had a settlement, a settlement at the Glorious Revolution, and that we had a Bill of Rights, which was indeed the grandfather of Bills of Rights. It's where the American one came from, as you'll see later, and so on. And so it was obviously a very important document. And I thought that it had come from a Declaration of Rights, and that was about all I knew. And I decided to investigate this, and so I rang up the House of Lords Records Office and said, does such a document still exist, a Declaration of Rights, and may I come and examine it? And indeed I did, and ended up being allowed. They couldn't give me a transcript of it, which is in itself quite remarkable, because, of course, if this had been anywhere else in the world, this document would have been hugely treasured and on display. And it wasn't even recently the British Library had a freedom exhibition, and I don't think the Declaration of Rights was present there, although they had the Bill of Rights, the other document. But the Declaration of Rights is actually the settlement terms of the Glorious Revolution. Now, why this is important is because at that time, the old divine right of kings, where the king was assuming absolute power in 1688 under the Stuart kings, King James and so on, that was put an end to by this settlement. And this particular document, the Declaration, was the fundamental contract by which the whole thing was settled. So we'll come on to that in a little while. But what you have in Magna Carta, and in essence what happened in 1688, incidentally, comply, or can be seen as complying, with the terms of enforcement under Magna Carta for claiming redress and remedy. Anyway, what is Magna Carta? Well, one thing, it's a presumption for liberty. It's a limitation of power. It stops the power being enforced by the state. It's very important because trial by jury is how judgment is created. So it's very difficult, as long as trial by jury exists, for a dictator to get hold, because he cannot enforce his rules. So this is a vital safeguard to our liberty, as trial by your peers, and that was one of the greatest things of Magna Carta, if not the greatest point of it. And of course it has a right of redress and a right of enforcement. Now, all that I'm talking about, some of these things have been repealed, and they say they're no longer statute law, but everything that we're talking about here is still current statute law. So what we got here is a current copy of what remains. There are 61 or 62 clauses of Magna Carta, and most of them have been repealed. But what remains, by statute law that is, there is a grey area there, but we can get into discussion on that. But for now, we'll just talk of what is extant. It's in the statute book, so not only is it in Magna Carta, it's also on the statute book, and so there's no question about its right to exist. It's there. And here you can see a copy, last printed, I think, in 1978, and what remains of Magna Carta. And there is this most important clause. And really, of course, if Parliament wanted to do away with it, it would be repealing its right to exist. And no free man shall be taken or imprisoned or disseised of his freehold. Disseised is to have his freehold taken, to be seized, in other words. To be disseised of his freehold or liberties, or free custom, or to be outlawed, or to be exiled, or anywise destroyed. Nor will we not pass upon him, nor but by lawful judgment of his peers, or by the law of the land. We will sell to no man. We will not deny or defer justice or right. So that's a very, very important point. Of course, a lot of us wouldn't think there's much when we talk about sell justice today. You need a bit of money usually to manage to get yourself sorted out in the courts, as we all know. And then importantly, notice the bit about enforcement. Shall not be infringed or broken. It shall be had of no force or effect, if it is.